Hey guys, welcome to today's Legal 101. Being a Monday, it's on employment and labor relations law. But just a few housekeeping rules. This week we're only going to have Legal 101 today, Tuesday and Wednesday. We're not going to have Legal 101 on Thursday and Friday. And neither are we going to have Legal 101 next Monday, Tuesday and Wednesday. It's because I have some commitments that are going to take a lot of my time. And therefore I have to pump brakes on this a bit. But if you miss me, if you miss my voice, then just please catch up on all the videos. I know some of you have been putting the videos on favorites. Please just catch up and then we can talk when we get back. Now we have dealt with a case in a while, and this is one of the cases that I liked. It is on redundancy, but we have spoken about the elements of redundancy before. If you scroll down to the 10th video I ever posted, I posted it on the 4th of March. You will see what I said about redundancy, what the law provides for redundancy. I'm not going to repeat it, although a lot of it came up in this judgment. But for me, the things that stood out are quite a few, and I will mention them. But first, let me just tell you what happened in the case. So somebody was employed by a company, and then in 2019, he was terminated. Now, 7 days before his actual termination, he was summoned by HR and given something called a mutual release agreement, where he was being told that they wanted him to sign it to indicate that his services were no longer required. Now, he tried to seek a reason for it and was not actually provided with it. Section 45 of the Employment Act provides that before an employer terminates the services of an employee, they must give valid reason. Now, what valid reason means is subject to determination by the court. Okay, and so he refused to sign it. 7 days later, he was actually issued with a termination notice, and he was going to be paid for 3 months in lieu of notice. Now, and they told him this time that the company was restructuring, that this was a redundancy, his services were no longer required. It came out later on that actually the company had merged departments, and when that happened, there was creation of the operations manager office. Now, the claimant this employee felt that he should have been given an opportunity to actually interview for this position, because the employers knew that before he joined them, he had worked as an operations manager before. So he felt he was not given an opportunity. And so he felt that he was just being kicked out, and that was unfair. Now, the employers, of course, put up a fight. They explained that they had paid him in lieu of notice. They explained they didn't need him. But of course, you will have to go back to the video on redundancy to see actually what people are supposed to do when there is a redundancy. The employee asked for various things, but I'm just going to mention the things that I thought were important to share today that I haven't shared before. He asked for payment of bonus for the last year before he was terminated, which was 20% of his salary. Now, bonuses are discretionary. The employer decides whether or not to give somebody a bonus. And this was actually provided by the same judge. The same judge also mentioned other cases where the courts have said as much. But this is the caveat. He said, if you have been giving somebody bonuses year in, year out, you're not complaining about the level of performance that they have been portraying. You've actually declared bonuses for that year, and you have paid people bonuses. Then there's no reason why you should leave somebody out. And for that reason, he got his 20% of his gross salary. Then the person also asked for loss of prospective earnings. He said, I am 52 now. I had hoped to retire at 60, so I want to be paid for what I would have earned in that period. And the court said, you have no right to work forever. There's actually no proof that you would have worked until you turned 60. You're still in good condition. You can still find a job. It's not like you have lost your ability to think or ability to work, physical, mental, etc. So therefore, I'm not going to award you this particular prayer. Okay? And then the person asked for their life insurance cover for 15 months. But actually, the court looked at the contract and said, for one to enjoy life insurance cover, then there has to be proof of an accident, incapacity of some kind. There was actually legal provisions for it in the contract, and so there was no basis for asking for the life insurance. Lastly, there was the issue of general damages for violation of his fair labor practices. That the termination caused him shock, humiliation, inconvenience. This person was earning 633,000 a month gross salary. So there was a lot of inconvenience to his life, a lot of distress, a lot of embarrassment. Now he kind of has to start from scratch. And the court said, okay, I agree with you, but you see that general damages is very much discretionary to the court, based on the facts of the case, based on how much you have been able to convince the court of the distress you have endured. And also the court will look at the compensation it has given you for unfair termination. And in this case, he was given 10 months compensation. That is 633 times 10. Okay, so when it came to damages for all this loss he allegedly suffered, the court only gave him 100,000. And this changes from case to case. It is based on what you can be able to prove to the court. So if you're saying I have been distressed, I've been embarrassed, what are witnesses saying? If you're saying I've been humiliated, I'm having a hard time getting a job, what are witnesses saying? You can't just say and not have proof. Now that is what I prepared for you today regarding this case. You'd have to go back to the video on redundancy again, like I said before, to understand the intricacies of redundancy. As an employer, you need to be very careful when you're terminating people. You actually need to give a valid reason. Okay, and as an employee, I have given you more than enough tools to prepare you for such things, and I think now it's just up to you to be strong enough if such things happen to you to reach out to an advocate. Know that the Employment Act actually is more biased towards the employee. That is usually the running joke or the running conversation, that it favors the employees too much. So take advantage. See you tomorrow for tomorrow's Legal 101. Bye.